Actions to be handled either by lenders or by active members of the state bar. Now, that too has had some comment, and that's why we have an amendment designated 29-2013, which is to clarify something that became apparent early on. That is that real estate brokers and salespeople routinely handle closing proceeds in the form of earnest money or escrow payments up front in purchase and sale transactions. So that is covered, we believe, if the amendment offered is attached to the bill. So at the present time, the bill that I would advocate going forward would be simply Section 2 of the substitute with the addition of the amendment. However, the amendment will be re-lettered from B, subsection B, to subsection G, and that will follow the provisions under Section 2.
So what you're recommending is under Section 2, as we come down through 10B, and it goes from B to E to F.
That's correct.
I don't know why it goes from B to E to F either.
You know, that's a good question.
We may have to look at that.
B.
It's because it's a huge code section.
Is it?
To make it short.
Okay.
Okay.
That was good.
Thank you.
Good.
And then have what is designated as this B on the amendment made. Is there now existing a G in that code section? Do you know?
Now, that was a question I was going to direct
might
to
pull out
legislative
section.
counsel.
Would you pull out 15, please, Ms. Lottie, and take a look at 15. I'm sorry, 44. Now I beg your pardon. 44, 14, 13.
There's not a G.
Not a G.
No.
There we are. All right, sir. We're back to where we were with the bill, and that is you're wanting to amend, and I'm going to. Is there any questions of members of the committee of Senator Stone, the presenter? I think we have one over here. Is that you, Ms. Evans?
Thank you, Mr. Chairman. I got an email recently expressing some concerns about how this would apply to commercial closing transactions, which traditionally don't take place the way we imagine and don't have the same protections that you would want for homeowners. And do you have any comments on whether that you believe this would apply to those commercial closing transactions?
If the transaction is handled by a lender, which is a party to the transaction, it would not. That's why the bill states either an active member of the bar or the lender.
Okay. Thank you.
Any other questions? If not, we will allow others. I think we have one other signed up. Is it William Phelan?
Yes, sir.
If you're here, we'd like to hear from you if you will come forward. And we'll let you have that chair.
Thank you, Chairman. Members of the committee. I'm a member of the Georgia Real Estate Closing Attorneys Association. My name is William Phelan. And we had brought the original Senate Bill 365, or asked Senator Hamrick to bring it on our behalf, which was then later substituted by Senator Stone. And what we were trying to do is to curtail what has gotten to be a more prevalent practice, what we call witness-only closings, which have now morphed into power of attorney closings. And here's how they're different than what we traditionally see in residential closing arena. In a witness-only closing, the attorney is only there at the ceremony to say, sign here. They act as a witness and notary only. They don't have any other responsibility or liability in the transaction. The slippery slope we've now seen leads to power of attorney closings where there is almost no attorney involvement other than telephonically. the borrower signs a power of attorney giving a third party the ability to sign the note, security deed, notice of rescission, and all other loan documents. We think this is contrary to public policy that's been in the state for many, many years. So we have this bill before us. Now, what's directly before you guys now is Section 2. I think you had a question about commercial transactions. Section 2 revises what we call the good funds law. And the good funds law only applies to lender-funded residential transactions. So it doesn't affect commercial transactions at all. It doesn't even affect cash transactions. And what we're doing in Section 2, or asking you guys to do in Section 2, is to say that only a lender or a Georgia licensed attorney can settle and disperse funds in a lender-funded transaction. Now, traditionally, lenders have been able to close their own loans in Georgia. And lenders are our clients, and we don't have any problem with that at all. It happens all the time, especially with equity line closings. What we're trying to do is to put the responsibility back locally with Georgia attorneys. And I guess you're saying, well, is this really a big deal? It is. It's not only a big deal for consumers, it's a big economic deal for the state. I did a quick analysis of 4 different companies that operate in this manner in 2002. Just 4 companies, which is a small percentage of what's out there, accounted for 16,000 transactions. Now, the rule of thumb in this kind of a transactional business is that each closing generates about $1,000 in gross revenue. Okay, gross revenue. So that's $16 million that is leaving the state because these 4 companies are all out-of-state settlement service providers. $16 million. I figured out that very conservatively, that's about 44 different legal positions that are lost out of state just by these 4 companies operating this way. Yes, this is an issue that we're working with the bar on through a formal advisory opinion. Now, that opinion is only going to affect the conduct of attorneys. It's not going to affect the conduct of non-attorneys, and that's why we came to the legislature to ask for your help to try and stop this practice of witness-only and power of attorney closings. It's just getting bigger and bigger. Other states have done some work in the last couple of years, most notably South Carolina and North Carolina. We're trying to be a little bit more proactive. In North Carolina, some legislation got passed last year dealing with these issues after a $2 million defalcation by a non-lawyer company that was handling settlements in that state. We want to nip it in the bud before we have a $2 million default.
All right. I think we've got a question for you, if I may. Is that yours, Mr. Bruce? Roger?
I just want to make sure I'm clear on it because it sounds like it's more of a financial issue than a legal issue that you're addressing based on what you just said, and that the intent is to stop the companies that are operating out of state from being able to do what lawyers could do in state. Am I reading that wrong?
Well, there's really 3 aspects of it. One's the consumer protection aspect, and we think that a lawyer who is regulated, subject to bar discipline and some other rules, is probably best equipped to handle the largest transaction that most people ever undertake. Okay, so from a consumer standpoint, we think that it's very important. And then there is the financial aspect of it as well, with that example that I gave you about the money that's basically flowing out of this state. And then the other part has to do with the law itself. The Supreme Court, through UPL decisions, unauthorized practice of law decisions, and formal advisory decisions, has set forth that an attorney has to be in charge of, they have to supervise the closings, they have to facilitate the conveyance process, they have to prepare deeds. There's certain things an attorney has to do. But those decisions are only good against attorneys necessarily, not so much UPL, but the advisory opinion is only against attorneys. They can't, the bar doesn't have the mechanism that you guys have as a legislature to affect the conduct of non-attorneys. I don't know if that answered your question.
Yeah, it does in part. I guess where I'm trying to go with this is, if this is a legal issue, where our citizens are at risk, that's one issue. If it's an attempt to prevent companies that are out of state from doing business in the state because we want to keep the business local, that's a whole different issue. And that's why I'm trying to get an understanding of the difference between the two, because I'm a little uncomfortable if the intent is to interfere with free enterprise, people being able to do business in this state. That's why I'm asking the question.
No, we're not trying to stop people from making money, basically, as closing attorneys. For a long, long time, attorneys have been responsible for handling the whole closing. We're seeing that that's being changed. We think that the old way is the good way, quite frankly. Now, to the extent that companies outside the state want to do business here, I think they need to do it within the rules. I have to operate within the rules, and I think they need to as well.
All right, we have another question over here. Ms. Oliver?
How many states now do not require attorneys to participate in closing?
That I do not know. I don't have an exact number. It's more. I do know that it's more prevalent in the West to be what they call a title state. In the Southeast and South is where you traditionally see more attorneys.
All right. And any other questions of the witness? If not, anyone else wish to address the committee on Senate Bill 365? We thank you.
Thank you for your time.
We'll close off further public input. The bill is now in the breast of the committee. Do we have any discussion on Senate Bill 365 among the committee members? There being none, the chair will entertain a motion. We have Mr. McKillop.
Yes, sir. I'd move to amend. I believe the author said he was only bringing forward Section 2.
Right. Well, first,
and
have to take a motion on the bill.
Move do pass.
All right. We have a motion do pass on Senate Bill 365. Any discussion on the motion? There being none, the chair will entertain any amendments.
I have an amendment.
Thank you.
I'd like to amend LC 295250S by deleting Section 1 and renumbering.
All right. And that will now begin Section 1 as what is identified as Section 2. That's been moved and seconded. Any discussion on that amendment? Not, the chair will call for the amendment. All in favor of the McKillop amendment signify by saying aye.
Aye.
Opposed, like sign. That motion carries. And we have any further amendments?
Yes.
Mr. McKillop.
I would move AM 29-2013 as printed and in everyone's folder.
And that would be added as a new paragraph G under Section 44-14-13, which is Section 1.
Yes.
Is that correct?
I believe that's right.
That's correct. All right. Is there a second to that amendment? It's been seconded. In discussion on the amendment, Mr. Welch.
In accepting AM 29-2013, will we not also be accepting lines 1, 2, and 3 of that amendment, which we now have removed by striking Section 1?
Yeah.
So I think we
better do it in two amendments.
So we really just need lines 4 through 8 of that amendment.
Actually, 6 through 8.
Yeah.
6 through 8, yes.
Identified as
6 through 8.
Paragraph G.
Yes.
In lieu of the B, that'll be identified as paragraph G on starting line 6. Does that everyone understand the amendment? That's the McKillop Amendment 2. Any discussion on the amendment? If not, the chair will call the question. All in favor of the McKillop Amendment 2 signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Do we have further amendments? I'm trying to read where that line, Ms. Travis, I don't think there's amend the substitute to Senate Bill 365. This is the same bill by inserting an exception between damages and semicolon on line 2.
When I prepared AM 29-2013, I thought the idea was to revise the Title 15 language. I didn't realize that the
Would be deleted.
intent was to amend the Title 44 language, but
All
I'll
right.
fix the title for you.
So we're not really in need of that amendment. or the one at line 3?
No, sir.
All right. Any further amendments? If not, the chair will call the question. Main questions are due pass to Senate Bill 365, LC 295250S, as amended as a committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign. That motion carries. Who will be responsible to that, Mr. Stone?
I believe we've had some discussion about Mr. McKillop.
He shows great interest in it.
Yes, Senator, I'll be with you afterward. I'll be glad to carry it. Maybe
All
I'll
right.
just touch base on one of mine.
Bring forward Senate Bill 292. Senator Albers. I noticed from the number of sign-ups we have today, the chair does not anticipate we're going to get everything heard today and completed because the House is to reconvene at 2 o'clock. But we will begin a discussion and hopefully get as much comment as we can before the end of that portion of it. Thank you, Senator.
Thank you, Mr. Chairman, members of the committee. Thank you for your time. We went through the merits of this bill the last time we had met, and you have been taken through it. I want to commend Representative Michael Hardin for all the hard work he did in passing a similar version of this in the House. So I don't want to take too much of your time today because I know other people that want to speak, but I'm going to ask you today, and I sent each one of you in form of a memo, a few slight differences, and I'm going to ask you to sub back the original version as passed by the Senate, which is should be handed out to you, which is LC 21-1745S. And there are a couple of key things I just want to highlight on there that are different, and I believe some of the testimony today will give credence to that, which is specifically outlining work that we had done in special needs and disability communities, elderly and nursing homes, and some of the work we had specifically done in meeting with various folks, both from the Attorney General's office, legislators in Florida, as well as meeting with DCH and other folks. I think the combination of the 10 items that I outlined in my memo will make that bill just a little tighter than it was. But again, I want to compliment Representative Hardin for all his hard work on that and his willingness to carry this in the House. So with that, Mr. Chairman, I will yield the question, seeing as we've already reviewed the merits of the bill.
Thank you. Questions of Senator Albers. Ms. Oliver?
Chairman, I'm just, maybe Graham is handing me right now, but when you gave the, Senator Albers is asking us to consider Amendment 292010 to the substitute for 292, which is 5237 ERS. Is that what we're being asked to do?
I think the one you were just handed, the 292010, was a proposal that applied to 295237. So I'm not sure how this may now tie in as to the proposal that Senator Albers has given us, which is going back to his as passed bill from the Senate.
That's why I'm also trying to put that together, Mr. Chairman, because I have the original as passed Senate bill, which is 1745S. So
Yeah.
there are three documents in front
We're
of me.
True, we do have, and I think this is Dobbs' amendment, and I will ask Ms. Dobbs, before we go any further, if you would just speak to this part of it, please, ma'am.
Are we talking about?
Bring your mic around.
I'm sorry. Thank you, Mr. Chairman. Are we talking about the amendments for the
Yes, ma'am.
AARP?
Your amendment is that proposed to what we have as a document 295237?
Mr. Chairman, the amendment that you and I discussed before the meeting was a different amendment. This was the amendment that AARP had brought to our attention, and because we weren't sure what bill version we were going to, let me ask Graham whether this has been passed out. Did he?
It
Oh,
has.
he's gone.
Which
It
one?
has. Do you? No, not that one.
No. I don't know. We got another amendment.
Graham, do we have the amendments for AARP, these two amendments that, okay, I'm sorry, Mr. Chairman.
Let me stop. I'm sorry to interrupt you, but whose amendment is being suggested here? We don't have a name on the amendment,
Oh.
29-2010.
Yes, this is another amendment, Mr. Chairman, that I
From
would
you.
like to, yes,
All right.
but not at this time. I think the amendment that you were discussing with me
All right.
was the AARP one, but I will be happy to proceed with this amendment if you
For
prefer.
clarification, is all I'm asking right now.
Okay.
Is the amendment applicable to 29-5237 as a draft of a bill? That's the one that was in your folder.
I'm sorry, what was the question again?
Is the amendment 29-2010
Yes.
an amendment proposed to the bill that was in the folder of 292, which is 29-5237?
Yes.
All right. That clears that part of it up. And you have another amendment you're going to pass out, which also goes to 29-5237, correct?
I'm sorry, sir.
You have another amendment.
I do,
Whose amendment?
but I'll be happy to address this amendment since we are searching for the copies of the AARP amendment. Would you like for me to address AM 29-2010?
Not at the moment. I want to just
Okay.
get all the amendments that go into which bill. And actually, I've just been handed 3 more proposed amendments. My reason I asked is to be sure where we're placing the amendments as a potential amendment to which of these draft bills we have before us. Now, I think all your amendments apply to the 5237. Is that correct?
That's correct.
All right, so we'll hold all those together for the moment.
Okay.
Thank you. You had a question. Is that yours, Mr. Hatfield?
Yes, sir. Just parliamentary inquiry.
Thank you.
LC 295237 ERS that's in our folder. Am I to understand that that substitute contains the language as passed the House on Representative Hardin's bill?
That is correct.
Okay.
That is what you have. And what's being offered is from the sponsor, Senator Alvarez, as a substitute would be Senate Bill 292-21, which is LC 21-1745S.
Yes, Mr.
Okay.
Chairman. And again, that is to specifically outline the areas for special needs, disabilities, retirement, nursing homes, et cetera.
Let me ask you the question that I've had presented to me on a couple of occasions. Does the proposal you have contain anything that deals with Medicaid? And if so, what provisions?
It does not drug test, Mr. Chairman, anyone who has Medicaid. However, if at any time Medicaid would cover the cost of drug tests, we would leverage that cost. But it is true that about a month ago, Medicaid was originally part of this bill, but we did take it out through the committee process in the Senate. So it is only drug testing those who are receiving TANF.
All right. Questions, Ms. Dobbs?
Yes, Mr. Chairman. Regarding the Medicaid issue, it is my understanding that Medicaid would not pay for any of these drug tests. Is that correct? Because Medicaid only pays for tests that are required by a physician?
We are not 100% sure, but it just says that if they will be covered, then they'll pay for them.
Okay. And then also, although you're indicating that this bill does not apply to Medicaid recipients, what about individuals that are in non-Medicaid home situations, that are elderly and that are still at home in home-based community services programs, and that are actually the recipients of TANF dollars for either their children or their grandchildren or their great-grandchildren? And we're concerned about whether or not these elderly folks will be required to be drug tested. And so this is what this amendment that we've now passed out would address. Do you have any objection to asking that the bill not include these individuals in the requirement of drug testing?
I've not seen the amendment, Representative,
I'm
but if I can
sorry.
see it, I would be happy to look at it.
And as I understand it, now that we are addressing Senate Bill 292, version LC 21-1745S, then the bottom half of this page would be the appropriate language for this amendment.
Well, you're talking now about what document? Your one.
It is the short piece of paper that we had with 2 amendments on it.
All right.
It would be the second half version for at the end of line 151 on page 5, adding the language that would.
Yeah, let's wait till we get to discussion on the amendments if we could on that point. You're good. All right. Any other questions of Senator Albers we have over here? Ms. Oliver?
One of the questions that's arisen throughout the series of bills is whether or not TANF recipients who are victims of domestic violence are required to be drug tested as they go into a shelter paid for with TANF bills. Isn't it true that this would cover victims of domestic violence who have to be drug tested before they go into a shelter paid for by TANF bills, TANF monies?
Well, thank you for your question, Madam Representative. Anybody who applies for TANF as a condition of receiving their benefits will have to pass a drug test.
So you agree that victims of domestic violence going into a shelter before they may go into the shelter must be drug tested?
Well, I would actually agree that we put provisions in there to assure that wouldn't prevent them from going to the shelter, because at no time would any services be held up and waiting for the results of a drug test, and that is in the Senate Bill 292 is passed.
Can you give me the language there, because benefits for a shelter are different than benefits for a financial check, and there's no eligibility for said shelter benefits are fairly distinct, although paid for by TANF. Can you direct me to the specific language on what specific bill that creates that protection?
I'm looking through it right now.
Let me call your attention to line 65.
This is fine.
This is where you're.
Yes, thank you. Mr. Chairman, on line 65, no assistance payment shall be delayed because of the requirements of this code section, and any payments made prior to the department's receipt of a test result showing a failure shall be recoverable.
As a practical matter, when does the victim of domestic violence have to go get her or his drug test, which will grant her the right to stay in the shelter? As a practical matter, how is this going to work if I'm running a shelter with TANF monies?
When an individual applies for TANF, they have a lengthy application process today. You may be familiar with it.
Yeah, I believe I'm talking about the victims of domestic violence and admission to shelters, which is a very different application process than what you're envisioning for financial benefit.
They still have to go through the application process, though.
Do you know how that works?
I am vaguely familiar.
Okay. I'm suggesting to you that this creates some pragmatic problems here about anybody running a shelter funded with TANF funds. Is it your intent, may I ask the question this way, is it your intent that victims of domestic violence must be drug tested before they may receive the benefits of shelter with their children or without their children?
Madam Representative, it is my intent that anybody who applies for TANF, no matter what the circumstance, would be drug tested.
So the answer is yes.
Correct. Anyone.
Thank you. Ms. Dobbs?
Thank you, Mr. Chairman. This is a question for the author also. Since TANF dollars are 100% federal funding, how will this save Georgia taxpayers money if it's passed?
Thank you, Madam Representative. TANF dollars are not 100% federal funded. In fact, close to a third of those are funded by the state.
And you have this from what authority?
From the budget offices.
Thank you.
Any other questions from the committee of Senator Albers? You have a question, Ms.
Thank you,
Stevenson?
Mr. Chair. I do have a question of the author. My question follows up on my colleagues regarding domestic violence, and I understand that once approved, there's a 48-hour window. The practical matter that she was referring to is the time that it takes for a victim of domestic violence and their children to have a residence. So my question is there a waiver of these notices in the application process so that the victim and children will have shelter while subjecting themselves to the proposed statutory scheme as outlined in your bill?
Well, again, I think if you go back to line 65, it says nothing will be delayed for them. So they can continue to get whatever benefits the state is going to provide to them, and however long it takes to get the drug test results back. And I do not believe necessarily they'd be subjected to anything. As a private business owner, I get drug tested regularly, and I pay taxes that help fund these programs. And as a firefighter, I also get drug tested, and I don't get paid anything, but I do it to joyfully serve others in my community and protect their lives and property. So I think it's not necessarily being subjective, but to level the playing field.
Well, subjective, level the playing field, those are just the words. So that my understanding is lines 50 through 53 will be waived in favor of 65 through 67. Is that in your bill?
I don't know if they necessarily be waived, Madam Representative, but I think they all work together.
Okay. Because they read very different to me.
All right. Mr. Bruce.
Senator, I'm just curious, what is the specific problem that this bill is trying to correct?
Mr. Representative, I think it's important that whenever the state spend tax dollars, that we do so in a good fiduciary manner. Each one of us took an oath for the state to make sure that we would make sure we're good stewards of those tax dollars. In the private marketplace and in public service today, or civil jobs, we already require people to drug test. And the last thing we'd ever want to do is someone to receive a state benefit and use that for illegal activities. And I think the perfect case to point out is the state of New Jersey conducted a study on their TANF recipients. The average person spent 5.8 years on the New Jersey TANF program. However, if they were using illegal drugs, they spent 12 years, more than double the time. So our goal, obviously, is to make sure that we don't encourage or enable that type of behavior. We want to do the exact opposite. We want to tell people that sometimes a little tough love is a good thing, and there's good positive results. And I do work on many charities in my district. And the tough love scenario works a lot better than the enablement.
Okay, obviously we're not in New Jersey, so I guess what I'm trying to figure out is there a specific problem in Georgia that we are trying to correct? It sounds like what you're saying is that you want to prevent something as opposed to correct something. And so there's a lot of money that the state pays out for a lot of different reasons, and I'm trying to figure out if there's a drug test anticipated for every dollar that the state pays out for any purpose, and if not, why just this purpose?
Well, thank you for your question, Mr. Representative. Unfortunately, the state doesn't have exclusive controls over that many things, although I would have loved to have used a similar bill for things such as food stamps, where there's a lot of fraud going on. However, we focus this bill narrowly on TANF based on the control that we have, and also following the 1996 Welfare Reform Act that was passed by the Congress and signed by President Bill Clinton that specifically authorizes states to drug test TANF recipients.
Okay, so there is, and again, I don't want to prolong this thing. So what I'm hearing you say is that there is no particular problem that we're trying to correct.
No, sir, that would be inaccurate. I believe there is a problem that could be corrected, because we know in any population of people there are those that may be abusing illegal drugs, and we certainly want to correct that. But this is a core ideology bill if there ever was one. There are those that believe that if we continue down our current path, that people will, or the problem will fix itself, rather. And then there is another school of thought that says we believe people should be responsible and accountable to themselves. And that's why I named the bill the Social Responsibility and Accountability Act.
Thank you.
Thank you. We're now about 8 minutes till 2, so we're going to be running close time-wise. Ms. Dobbs?
Thank you, Mr. Chairman. Mr. Chairman, I'd just like to ask the chair, I think there's some disagreement about the federal funding, and I know that there are representatives from the department here that some of the members would like to ask some questions
They'll
of.
have an opportunity to hear from everyone who signed up.
Okay, but I do have a last question for the author, and how he envisions that this drug testing program will work logistically. Do you see that the applicants will take the drug tests at the DFACS offices so that it'll be their responsibility for storing and sending out the bodily fluids for analysis? Or do you see them having the drug tested in the private sector, and then do you have statistics on how many drug testing facilities that there are available, and especially in the rural areas, and how logistically these...
I've got a lot of questions there. Why don't we divide them up?
Just explain to us logistically how you think it's going to work.
Thank you, Mr. Chairman. Madam Representative, we as a state do not want to get into doing something inside of our core, so we would outsource that to a third party. And there are drug testing companies all throughout Georgia and the United States. It's become mainstream for testing, again, in civil service jobs as well as the private sector for many decades now.
Thank you.
Thank you. And we have over here Ms. Evans.
Thank you, Mr. Chairman. Senator Albers, would you agree with me that TANF benefits are really going to those who are really down on their luck? We're talking about temporary assistance for folks who can't make car payments, or probably don't even have a car, can't make rent payments, can't make utility payments. We're talking about folks who are looking for, at maximum, $280 a month in benefits. Would you agree with me?
Representative Evans, I really don't pretend to know what each individual circumstance of a TANF recipient is or is not.
Would you agree with me that $280 a month is not a lot of money?
I guess it's in the eye of the beholder.
Would you agree with me, though, that the cost of these drug tests that we're going to require the TANF recipients to pay for out of pocket is about 16% of what their maximum benefit could be? So to these folks, the cost of a drug test is a lot of money out of $280, which is probably not a lot of money to most of the people in this room.
Well, I think if you look through the Senate Bill 292 is passed by the Senate, you'll see they're going to get that money back as long as they pass the test. However, if they fail the test, I'm perfectly comfortable with them not getting their $17 back.
Do you have any concerns, however, though, that for these folks who are in really tough times and are trying to seek assistance to get by temporarily, $17 might be an absolute hindrance to even starting the process to get TANF? Do you have any concerns about that in any way to address that concern?
I do not have any concerns about that.
You don't have any concerns about putting a roadblock in front of folks who we have no reason to suspect are not other than law-abiding, non-drug using citizens?
I think we're getting argumentative at the point.
Sorry, Mr. Chairman.
It's all right. Any further questions?
That's it.
Mr. Welch. Oh, I'm sorry, Ms. Hatfield.
Thank you, Mr. Chairman. Just a quick question. Can you explain the primary differences between your version of this bill and Representative Hardin's version?
Yes, thank you, Mr. Representative. There are several different items. I did get a memo out to the committee, but let me just outline those very briefly for you because I know we're in a crunch for time. The one is the clause for benefits being delayed while processing a drug test was one of them we just recently talked about in this committee meeting. The next one was description of how long until you take a drug test, which is up to 48 hours. As well as it changed the timelines to encourage people who get healthy and go to rehab to get back and to be able to test again once they're clean. It also talks specific about using a cotton swab test, which is much cheaper, much less intrusive, and considered to be more accurate. It gets away from any urinalysis or blood work, which we think is unnecessary. It also puts in specific language for protections for HIPAA and other things we work with the state of Florida and the Attorney General's office. It does talk about the initial test is paid by the recipient, but they are refunded if they pass that test. It also says that if somebody does fail the test, the department will give them at least options of where they can go outside of the department to get drug rehab, because I think that's important. Ultimately, we want folks to get healthy and to get clean and back into society. It also talks about the exclusions for disability, special needs, elderly, nursing homes, and things of that nature. I believe many people either today or tomorrow will be testifying to that fact, that we worked very closely to make sure that we had targeted our intended audience and no one else.
Just one follow-up to that. Obviously, there are two bills here, and probably this needs to end up in a conference committee, I would assume, at some point. But do you have any objection, or would you have any objection to the committee just adopting what was already passed out by with Representative Hardin's bill for the purpose of getting it on to the floor? Because a lot of these issues we're talking about here sort of raise new points that are going to, in my opinion, might lengthen the discussion. And the idea is go ahead and get the bill out, get it passed, and get it on to a conference committee.
Well, my purpose for bringing it back is if you look at the spirit of the bills, they do the same things. In fact, my guess is the very same questions were asked here today were probably asked about HB 861 because they follow the same suit. My concern is the good folks that we have worked with through this process would have felt as if they went, their concerns went mute when we did not want to specifically target them. And I want to make sure that if this does face a legal challenge, that we've done our best job up front. And I think this can pass as the original passed by the Senate and pass through the House, and it will be done and go right to the governor, who is in support of this bill as well.
All right, thank you. Ms. Dobbs, please.
Thank you, Mr. Chairman. One very last question for the author. I understand from your presentation that you have the best of intention on making sure that the individuals that you suspect may be on drugs, that this bill will help them in getting clean so that they can receive their TANF funds, and that it not be a punitive bill to punish those individuals and their children and families. Have you considered whether or not that perhaps another possible way of handling this issue would be to provide that if someone does fail the drug test, that the bill allow them a certain period of time in which to enter a drug rehabilitation program? And we've had testimony in subcommittee that those generally take approximately 3 months, but say give them 6 months to enter into a program and complete the program and then be retested before the actual TANF dollars would be removed, or that they wouldn't be eligible for receiving them.
Appreciate your question, because I think we're very close to what you're saying, and there are specific provisions in there in Senate Bill 292 that does just that. However, it will not pay their benefits while they're still using illegal drugs, but it gives them the opportunity to retest at a much quicker rate once they are clean. So the goal again is to get people clean and get them back in, but I don't think it's right of the state to continue to pay those tax dollars before somebody is clean.
And then lastly, with regard to a fiscal note, have you taken into consideration the effect on the cost of additional foster care should some of these individuals fail the test and not be, and be prohibited from staying with their children, and if they don't have family members in Georgia, that they would indeed lose their children to foster care?
I'm glad you asked that question, because we spent considerable time making sure we were protecting children at all costs. And we changed the bill in the original one to having only one parent that could pass the drug test, as well as a other guardian could pass that test as well, to make sure that they would have all options to keep families intact. However, I contend with you, with both parents using illegal drugs, it's probably not a good home life for those children to begin with.
So do you know what the impact would be on foster care?
We didn't believe there would be impacts to foster care based on the work we did and the work with the audits and accounts folks.
Thank you.
All right. I don't believe we have any further questions, Senator. We're now at the 2 o'clock hour, which unfortunately we need to get back. We have a scheduled tomorrow meeting at 2 o'clock. I will adjourn today and not take any further testimony on 292, but I'd ask everyone to please stand by for continuation. This will be the first bill we'll take under consideration when we reconvene tomorrow at 2 o'clock.
Thank you, Mr. Chairman. Thank you, members of the committee.